Welcome to the Melinda Eitzen Show. I'm Melinda. We are so lucky today to have with us ethics attorney, Jeanne Huey. Jeanne, thank you so much for being here.
Thank you for having me. We don't get to see each other often enough.
I know, I agree. So what does it mean to be an ethics attorney?
It means that, for the most part, my clients are lawyers. I consult with them, I advise them, I defend them in grievances for violations of ethics rules, most of which can be avoided. And so I like to be on the front end of things when they're putting policies into place, when they are training their staff, how to work with clients. These things are a lot of things that we can put in place to avoid them getting in trouble and avoid the clients becoming unhappy. So that's what I do.
That's great. Well, and some ethics are obvious, like don't steal from your client.
Right. Which is very rare, actually.
Yeah, that's not what most people are doing to get in trouble. But some are not clear. Like literally, I have had to call a lawyer like you, it might have been you, before to say, hey, XYZ is happening. What's my ethical duty? So it's not always crystal clear. Can you give an example of what isn't so obvious?
Sure. So we have rules which are personal duties that the lawyers are obligated to perform. Some of them are for clients, duties to clients. Others are duties to the court. Those make sense to most people. We also have duties to third parties. Okay. Who's a third party? Well, you're thinking about maybe if it's a court case, a witness who's not involved in the case except to be a witness. That's a third party. But what's not obvious in that rule is that also the other opposing party, they're a third party. And so when the rule says you should not unreasonably burden, harass, or take action to simply just harm or cost somebody money, a third party. Most lawyers even think, well, that just means a witness, but it doesn't. It means the opposing party as well. So clients need to understand this because, as you know, there's a litigation strategy that says, well, we'll just spend more than they do.
Right.
They'll run out of money and we'll send some frivolous requests. Let's subpoena, and I've had this happen. Let's subpoena everybody in the neighborhood.
Oh, my word.
And then that costs a lot of money, as you know, and takes a lot of time.
So that could be an ethics violation.
Absolutely. The court itself could deal with that directly, but it could still be an ethics violation. And lawyers forget the court has a duty to report ethics violations that are egregious. And even if the court sanctions you, the disciplinary counsel, that's the state bar's lawyers who handle grievances, they can still bring a charge. So
what are the most common complaints that clients have against lawyers?
A super easy answer. Failure to communicate.
And you know, I joke that in marriage, they always say the secret to a good marriage is communication, but communication is not actually easy. Now, it's a different kind of communication with your client, but what's the problem? Why aren't the people communicating?
Well, okay, your premise, it's a different kind of communication. This is the very problem. Because the client doesn't fully, unless you've told them, understand that it's a different kind of communication. Okay, if you have your mobile available to the client, if you're texting the client, these are things that make it very convenient and efficient for you to communicate. However, there are also indicia or means by which we communicate with our friends and our family. And it's very harsh to say, well, Mr. or Miss Client, I'm not your friend.
Right.
And in fact, you're paying me a lot of money every minute that I spend talking to you. So there are ways to set those expectations by explaining to the client up front. You know, and I know that after the first bill, if the client has been relentlessly demanding your time with calls that maybe because they just need some hand-holding or they want to understand the process, which is completely fair.
Yes.
But at some point you have to bill them for that. And when they start to understand that they're going to be paying for that.
Yeah, it's expensive.
Sure, and you can put policies in place as simple as So one of the most common things is this email string, having email be a conversation throughout the day. Well, we do that at work with our work colleagues, with our family, but it's very expensive to do it with your lawyer. So I would tell lawyers, tell your clients, email me as many times as you want throughout the day. Okay? Or make a note throughout the day as you think of things, and then send me one email.
Right.
And the next day, I will, go through those.
Combine
quickly.
it all.
And if there is something in there that needs responding to, I will respond to it. And but we can't have a back and forth conversation every day. If you say that to the client at the beginning, they start to think about it, and it's a boundary, yes, but you're also protecting them from ridiculous bills.
Yes. I like to have a conversation on the phone or the Zoom, now that we do Zoom, with people. If it's any more than very basic information exchange, I don't like to give a lengthy explanation or try to do strategy via email, because it's a back and forth. I want to be able to say, well, if this, that, what about this? I want the client to be able to live converse with me about it. So I often will reply and say, hey, let's set up a time to talk about this. And then we get on the phone. And then I like to send a summary of the call or the Zoom by email and say, we discussed this, we decided this. So the client can look back and say, oh no, I didn't think we said that. If it avoids confusion.
Well, and that is the absolute right thing to do. The summary is important. You will be surprised to hear that when things go south and lawyers get in trouble, they will often say, well, I brought them in and had a face-to-face meeting.
Yes.
Because it's also nice to see your client,
yes,
get their reaction. If it's an important decision,
yes,
to be in the room together. The problem with that is, frankly, there's a younger generation of lawyers, clients, and people working for the state bar at the Chief Disciplinary Counsel's office, for whom electronic communication is everything.
Oh, because that's how they primarily communicate. Oh, so interesting.
So the question will be, if there's a sensitive case, very important. My client has brought the client in many times, and even had the paralegal or legal assistant there with them.
Yeah, a
taking
witness.
notes, a witness. And I will get the question, well, but where's the evidence of that conversation? And of course, you and I, as lawyers and litigators, we know that what people say is evidence.
Yes.
But they want a piece of paper. Where's the email?
They want my summary.
They want your summary.
That paralegal sitting there could send the summary too.
They
could create the summary for the lawyer.
Saving that time. And it is very hard for anyone to refute what happened in a meeting when you send that follow-up email, especially if it says, if this does not comport with your understanding, or if you disagree with anything I've said here, let me know immediately.
Yes, yes.
And then their silence is acknowledgement that your report was accurate.
Yes, and they like it. I just had a client say, oh, I love these summary emails. Please keep them coming. Because especially in my industry, divorce, people are, they're not at their best.
Right.
And so they're discombobulated and they're not always, completely present during our conversation. So it helps them to have this summary to go, that's what she said. I wish my doctors would do that. When I go to a doctor and they give me all this information and nobody's writing it down, and then I leave and I'm like, did the doctor say this or that? Because same situation, it's stressful. You're getting some diagnosis that is unpleasant, or it's hard to not have it in writing after the fact, even though I want to be in an in-person conversation.
Well, it takes a little extra time, but it's worth it for the client's understanding, like you say. I mean, going into a doctor, I always want another person who can listen.
Yes.
Because I often can't, or the person whose appointment it is can't listen. So I will tell a client, I don't know if you've ever done this, if they're in a Zoom call and I can see what they're doing, or an in-person meeting and they want to take notes, and I just say, you don't need to do that. I'm going to send you a summary of everything that we've discussed, right? And if you have action items or things that are on your to-do list, I'm going to send you that. And they're so relieved
Yes.
because, again, they don't have to do 4 things at once. And this, what you're doing when you say, should we do this or if we do that, these are strategy decisions.
Yes.
And you're asking them to undertake this risk-benefit analysis, right?
Yes.
The risk, and it may not be something they do every day. So just having them listen, and I bet you that your clients often go back and look at those emails more than once as they digest little bits, right?
Yes.
Like nuance. So
yes.
it really pays as the lawyer to put as much detail in as possible. Because what you might think is important as the lawyer may not be what the client's focused on.
Oh, for sure. And I always say they know their case better than anybody, right? It's their life. So I really need their input, and I need to not assume, oh, this is definitely the path, because every case is different. Okay, I have another scenario for you. We have rules we have to live by. Clients don't always know that. And clients sometimes, every once in a while, will say to me, you work for me. I insist you send a letter to them that says blah, blah, blah. You know the blah, blah, blah in this circumstance is not kind, right? I want you to go send hate mail. Or I direct you to file a motion about emergency motion about blah, blah, blah. And in my professional judgment, that is not the thing to do. I don't do it. I tell them I'm not doing it. So what am I going to get in trouble for not doing it? What do I do to help them understand how this works?
All right. Well, you can't, it's 2 parts. You can't devolve into, I'm going to be in trouble for not following the client's direction, okay? Because that rule of competence and diligence that we have, the comments to those rules are very instructive, actually, for lawyers to keep going back to. Those are the meat sort of around the bones. They're not binding, but they help understand, oh, this is why the rule says this, okay? And part of that is that the client sets the goals. They determine the goal of their case, of why am I hiring you?
Yes.
This is my goal. They decide that. You don't have any part of that. You can help them refine it, but the means to accomplish the goal is what they're paying you for, to decide. Sometimes you have choices, right? The means could be, and this is part of my, not everybody has the platinum package lecture, which I won't give you right now, but the means could be 15 depositions. That could be legitimate, only if the client can afford it, right? But we can't afford that. We are going to say we are going to do depositions on written questions instead and get some record. These are the means. And you have all of those in your data bank because you're an experienced lawyer, right? And you ask the client often which one, based on cost a lot of the time. That's why an estimate is a great thing.
Yes, yes.
If we do this, it's going to take this many hours and cost this much. Your other choice is this. The client gets to make those decisions. Sometimes the means are clear cut and there aren't choices.
Yes.
And that's where you're sitting them down and saying, this is what we're going to do to get you to here, from A to B to C. If the client doesn't like that, or they want to take a different route, the lawyer cannot keep thinking, oh, I have to do what the client says. Absolutely not true. You decide the means, but more importantly, you have to put it on the client and remind them that your job is to do what's in their best interest.
I
That's your
usually am able to refocus by saying, so am I remembering that your goal is X? Is that still your goal? And then they say, well, yeah, that's my goal. Then I say, well, what you're instructing me to do, in my professional opinion, is not getting us towards that goal. Quite the opposite. The judge won't like it. We'll lose credibility, blah, 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 blah. And usually that gets me there. But sometimes they're not at their best. And they're like, no, I want you to do this. And then I just have to say, well, you'll have to hire another lawyer. I mean, I'm not going to do that.
Right.
I'm not going to do something against the ethical rules or against my professional judgment that will hurt your case. That's silly.
Right.
I had a doctor client, and the doctor was telling me, no, you work for me. And I said, doctor, if I came into you and said, I have a problem with my arm and I know the problem is you need to cut my arm off of my body. That will solve the problem. And you know that's not what should happen. You're not going to cut my arm off my body. You'd get in trouble. You'd probably be in ethical problems and criminal problems. So that's what you're doing with me. You're trying to tell me to do something that I know better because I'm the lawyer. And that did help the doctor a little bit.
Well, you're refocusing as saying it's not in your best interest, as I said.
Yes.
And here's why. And here are the bad things that can happen.
Yes.
Or I like to just use the phrase, bad things will happen. I get this from my partner, Richard Hunt, which is, it's brilliant and old school. Because if you list all the bad things that might happen, well, you can't list all of them, can you?
Right.
So if you miss one and that happens, they're going to say, well, you didn't tell me that could happen. Just telling the client, bad things will happen if we do this. For example, I can give them some examples. But the idea that you can anticipate, for example, in family law, which I did 12 years in exclusively, we can anticipate the kinds of things they might ask us to do that aren't going to be in their best interest.
Because they're mad, they're upset, they're emotion-driven.
But knowing that, I would tell every family law lawyer and every client to expect this. Do an FAQ, right? A fact sheet about the parameters of what you can and cannot do under the rules. The court might have their own professionalism guidelines that you have to follow. For those who practice in federal court, who have federal court cases, those judges make the lawyer sign professionalism guidelines. Those aren't ethics rules. Those are things like, if it is not hurting your client and the other side wants an extension, you should agree. Because the judge is going to give it to them anyway.
Right. Don't waste our time.
Don't waste our time. But you know that, and the lawyers know this, but why can't the clients know it? Why not share it with the client at the beginning?
Yeah, I attach to my contract for legal services with my client, the rules of professional conduct. So that later I can say...
You mean the...
how I'm supposed to...
Texas Lawyers Creed.
Yes, that's what I mean.
And by the way, there's a rule that says you're supposed to do that.
Oh, well,
we should all be doing that. Do you walk through some of those highlighted rules about cooperation, right? We were talking before, and I know every lawyer knows this, that in litigation especially, the client's not familiar with the courtroom and the way things go on there. And I see grievance after grievance that starts with, I felt like my lawyer was working for the other side because when we got to the courtroom, they shook the other lawyer's hand. Right?
You're like, what?
You know what? That's where they are at the moment. That's where they're feeling. That's the enemy. If they knew from the moment they hired you, but this is how lawyers, we're professionals.
Right. We're going to act
We have to comport ourselves a certain way. The judge expects it. The state bar expects it. Everything. So if they know that, it won't be a surprise. Try to eliminate, right, as many surprises. And for the client, I would ask questions. Is there anything I should know about this hearing? What's going to happen?
Yes.
Because if they feel like they're not getting the information, one of the things, you can tell the audience what's going to happen in almost any family law hearing, because you're third or fourth on the docket. What is the judge going to say?
Right.
Go to the back of the room.
Try to settle.
And try to resolve it. Have you two talked?
They always say that. Have you two talked? I have always tried to settle it by the time I get there. I am not at the courthouse if I haven't tried to settle it.
Right.
So I can always say, but sometimes the other side won't talk to me because they're too busy. When you said communication, a lot of it is just the lawyer not even calling back, right? Not responding.
That happens. And again, that has to do with the policies and procedures of the lawyer's office, because if they have those, as any office, professional office should, and follow them, it should never happen that the client feels ignored.
Yes.
Or disrespected, and again, a FAQ sheet. I see this a lot in personal injury firms. Okay. High volume practice. Many legal assistants are hired. And they're assigned to cases. And the client is told at the beginning the different levels of communication, right? If you want to meet with the lawyer, call, make an appointment. If you want a phone conference or if you want a Zoom conference, email this paralegal and we'll set it up so that they have the power. Give the client the power
Yes, that's smart.
to know how to contact you and when.
Yes,
Okay.
that's smart.
Because you and I know paralegals and legal assistants have a lot of knowledge and they know most about the case. They're dealing with it every day, seeing all the email traffic. There are basic questions they can answer. It's not legal advice.
Right, right.
Most of what the client wants to ask a question about doesn't require a legal advice answer. It might be procedural. It might be, what's the latest? Did we, they're uptight about a deadline or something. Is that, where are we on that? Having someone they can always call or text will help them. Now, from the lawyer side, I've got to say, the requirement is that we promptly respond to reasonable requests for information. And I defend lawyers every day before the state bar, and we have to focus on prompt and reasonable. Prompt is not immediate,
Yes.
and a reasonable request is not constant demands for a call about just any old thing. So it's a constant educating of the client.
Yes.
Here's how my office works. When I'm in court all day,
Yeah,
how
I
can I
can't
return
promptly
a call?
respond. I'll tell you, in modern times with texting, I am like really great communicator in my opinion. I try very hard. But if I'm in court all day, it is impossible. I cannot be texting someone else. I have to be present in the courtroom, listening, doing my job. And I had a client once, no joke, I hadn't responded for like 3 hours. And she called my office and said, "Is Melinda okay?" And they said, "Yeah, she's fine. She's in court." And she said, "Well, she's never taken this long to reply to me." And I thought she must be dead. 3 hours. So in a way, we do ourselves in on the
well,
expectation.
That's the old adage. You teach people how to treat
I
you.
know, it's true. Because I'm like 10 o'clock at night. You know, I'm a little workaholic-y.
Me too.
And then I laughed when she was like, truly, like she wasn't being funny.
Sure.
She was truly alarmed for my well-being.
So one mistake that lawyers make in that scenario is saying, well, if I tell the I call him a VIP client maybe,
Yes.
who's got a lot going on right now in the case.
Yes.
So they have a reason to want updates and things. If I tell them, well, I'm on another case today or I'm mediating, the client doesn't want to hear that.
Right.
The trick is, it's not a trick, but the client needs to have the confidence that you're always there for them, but with these boundaries of, I will promptly reply, not immediately,
Right. Because I'm in court.
or I'll reply within 24 hours.
That's really more realistic.
It's more realistic. And the worst thing I think that a lawyer can do is tell them how busy they are with something else.
Oh, right.
Because that makes the client feel, well, they put this other case before me.
Right.
If things go south, that is what they are going to say.
Right. Right.
And we never want our clients to feel that way.
No, no.
They don't have to come to terms with the reality of our practice.
Yes.
That we're in the office, we're out of the office, we're in mediation.
Right.
They know that.
Right.
But emotionally, they don't need to hear it. And you don't need to tell them where you are or why.
Yes. So staffing, we're back to staffing can help with that. So I tell my clients, copy my paralegal on every single communication because my paralegal knows I'm not available. I'm in court.
Right.
But my paralegal can say, "Hey, Melinda's not available, but she will be at 3 o'clock. How about if she talks to you at 3 o'clock?" Like, I don't believe in taking a message. In my office, nobody takes a message for me. They put you on my calendar. So
That's
the client
brilliant.
is not sitting there worrying about when she's going to call me back. They know Melinda's talking to me at 3. So if there's a problem, like my calendar is so thick that's impossible, then they might have to take a message because then I'm going to have to squeeze them in a place the person couldn't see on my calendar. But usually there's some daylight on my calendar, and then they're not worrying. Because otherwise, people in a panic, they'll just keep calling. They'll call every 20 minutes, you know. But if they know I'm talking to Melinda at 3, they can take a breath and talk to me at 3.
It's very difficult. And I know you say family law is particularly difficult, but in every kind of case, commercial litigation, it could be a multi-million, billion-dollar suit, bet the company suit. Those people dealing with that suit at that company feel the same way that, a probate client or wills and estates or immigration. Something is very important. They face a risk, a danger. They're unhappy about being in a lawsuit. That's universal.
Yes.
So this is where the attorney as counselor comes in. One of the reasons your clients want to talk to you, I know this, is because you're very comforting and reassuring. You're vastly knowledgeable and experienced, and they trust you 100%. And sometimes they just need to hear from you. How do you manage a caseload with all of those people and not fall into the I need to hold everybody's hand every day, because that's impossible.
Yes. I mean, that's the reason I like being in a firm. So we have, I'm saying 11 and a half lawyers, because I have one that just is graduating and taking the bar in July. So I'm calling him a half. But we have 11 and a half lawyers. We can pinch hit for each other. And if you introduce that person to the client early on, then they know sometimes I'm going to hear from Josh instead of Melinda, and that's okay. And most of the time it's me. Sometimes I take work over so I get to hear the complaints of where they were. And people do not like it if they thought they were hiring one lawyer and then another lawyer just took over their case and they don't know why. And it's typically a younger, less experienced lawyer. So I don't believe in doing that. But if I say to the client, your team is going to include me and a younger lawyer so that somebody else knows their case and can respond to simple things when I'm not available, that's one path to help that situation. But lawyers have to be careful not to let themselves get too busy.
Right.
If they're a solo and they can't handle the caseload, it's okay to say no. Don't take another client on until you clear a case,
So this is, the grievances come in for lack of communication, but also who is grieved? Solo, small firm. And the younger lawyers in particular, they're fearful. They take every case that comes in the door because another one, they're afraid another case might not come in.
Right.
And they have to believe that it will.
Yes.
Because taking a case outside of your area of expertise
No.
is always a mistake.
Yes.
And I'll tell you right now, family law is not paint by numbers.
This is not to be dabbled in.
It is not to be dabbled in, nor wills and estates. Right?
Oh,
These are the things that that happen. So this idea that you only take a certain number of cases, and then the idea that you have a team. This comes down to what is the most important document for communicating with your client. Do you know what it is?
No.
It's the fee agreement.
Oh.
I explain it to clients as, like, when I was in family law, I said, this is the instruction booklet in the board game. This is the rules by which we are both going to play.
Oh, that's smart.
So it says what you're going to do to the client. You're going to make yourself available. You're going to let me know if you have questions before you report me to the state bar, for example. You are going to pay me. This is how much. But I am going to do these things. And the things that are in there, my fee agreement's about 18 pages long. Every fee agreement needs about 24 to 28 provisions. And lawyers often say, oh, it's too long. No, it's the most important thing. It sets the rules of the game, and it also puts up those boundaries and parameters. Okay. It says how you're going to bill your client. If you want to get paid, you have to bill your client. You have to do it on time and in the way that you said you would.
Oh my goodness. I've taken over cases where they never got billed. 6 months passed and then the lawyer gave them one bill. Can you imagine? Like, how do you plan for that?
Well, I use language that I got from my good friend, Robert Toby, who's an experienced lawyer, as you know. And it says we bill every 2 weeks. The reason we do this is so that you can see the level of activity.
Right.
And then if you think it's too much
You can
or
tell
too
us.
little, you can tell. It's a constant
It is
form
a
of
great
communication.
feedback. Okay, so this has been so helpful. Great information and advice. You practice in where? Dallas?
I
Dallas
practice in Texas,
all over Texas.
all over Texas.
That's excellent. So people can find you. We'll put your information on the screen, but how do they best find you if they wanted to?
Well, Hunt Huey PLLC is my firm, and we're on the internet. If you Google my name, you may come up with, it may come up that I'm an author about of a book about raising children in Japan, which I am. But that was a long, long time ago. But it's still there.
Oh,
you can
that's
see a lot of
great.
things. But if you go to Hunt Huey, you can find me easily. Of course, the state bar lists every lawyer in the state of Texas. If you want to find a lawyer, that's a good place. And we do ethics and business litigation. And my partner and I both do ADA and FHA defense all over the country.
Oh, that is great.
So we stay busy.
Well, you have been such a great resource today. Thank you so much for being with us.
Thank you for having me. So good to see you.
That's great. Thank you for tuning in. Now, whether you're a client or a lawyer, you know some of the ethics that are of concern. If you're the client, just communicate more. Ask for more information. If you're the lawyer, just communicate more. Either way, that will help. Thanks for tuning in, and we'll look forward to seeing you next time.